Well, good morning, ladies and gentlemen. By the clock immediately opposite me on the rear wall, it is now 10 o'clock, so I believe we should begin. One of the things that you will notice if you're not familiar with these offices is that every clock reads a different time. And so there has been a slight tendency for times of commencements to vary just marginally as compared with your own watch or phone. My name is Rhyn Smith. I have been appointed on behalf of the Secretary of State for Communities and Local Government to examine the Tunbridge Wells allocations local plan. I will introduce at the rear of the room Lynette Duncan, who is the Programme Officer for this examination, who I'm sure most people in this room will have met. If you have not done so, she is the very capable figure behind all of the communications you've been receiving, and do take the time to say hello to her during one of the breaks. What I plan to do is to introduce the Council and the representatives who will be speaking in this morning's session after I've made some initial observations about this venue and the arrangements for today, and given that we're resuming after a gap, arrangements for hearings over the coming few days. I would like to thank the Council very much for use of this venue. We will be sitting here today and for a half day tomorrow, Tuesday and Wednesday morning. Wednesday afternoon, just to remind you briefly, is reserved for site inspections in the Crane Valley. And then on Thursday, sittings will move across the corridor into the Council chamber, and that's when we'll be hearing matters in relation to Paddock Wood, where there has been a certain amount of local public interest. Toilets, if you need them. The gents' toilets are immediately opposite this room on the other side of the corridor. The closest ladies' toilets are in the lobby to the Council chamber. Turn left out of these doors, immediately to your right into the lobby, and the ladies' cloakroom is suggested that's where the ladies' facilities are. In terms of fire drills, there are, I'm informed, none expected today. So if you do hear the fire alarm, it is the real thing and you will need to leave the building. The closest means of escape from this room, if we leave through the doors to my right, turn right, at the far end of the corridor is a blank door marked as a fire exit with a panic bar. Press the bar. That will take you into a stairwell that will lead you to the base of the building and to the exterior on Civic Way. And the Council staff who are here will act as marshals in those circumstances and will conduct you to a muster point, so and take their instructions. You will note that I'm speaking through a microphone. One of the things that we have been aiming to do in this examination is to take a digital recording of all proceedings, and after a minor glitch on day one, when we struggled with the technology, in fact that has been a very successful process. So again, I'd like to thank Council for their innovation in that respect. So the proceedings of today, digitally recorded, will be placed onto the Council's website and will be available for free of charge for use by everybody who's been involved in these proceedings. If you're speaking and you're using the microphone, they have a relatively narrow field, so you will have to speak quite close to them. If you want not to be picked up on the recording, then you will need to move away from the microphone and make sure it's switched off. Please do try and remember, and this is something that I'm spectacularly bad at, please try and remember to switch the microphone off when you are not speaking, so that inadvertent remarks don't go to the recording. And also, critically, because we have a long session today, and apparently the batteries in these devices aren't very robust. So your cooperation on that regard would be much appreciated. In terms also of other matters, information technology, you will note that I don't have the normal document wall behind me that a number of you may have been familiar with inspectors on local plan matters or large examinations having in the past. That's because I'm referring to the examination library online using my laptop, trying, if at all possible, to be a less paper examination, if not paperless. Moving on then, the arrangements for today and the rest of the week are set out in a combination of the version 4 programme and revised agendas that were issued on the 23rd of November, does everybody who needs to have sight of these, particularly those people that are speaking today, but is there anybody else who needs to have sight of these and doesn't have them for any reason? That is extremely good news. Now, I'll just remind you, in terms of hearings, this examination is proceeding through two sets of hearings. Initial hearings over 3 days in November that are now complete, that aimed to examine the strategic relationship between this local plan and the adopted core strategy that it seeks to implement, taking account of national policy and guidance. And those discussions are discussions that were focused around questions of principle relevant to multiple policies, proposals and places, rather than being site-specific. And then, and we're very much at the transition point now, we're moving into a set of hearings today, Wednesday and Thursday, and on the 8th and 9th of December next week, that will focus largely on individual places. I think I might need a different microphone. Let me just try. That one is performing now. One possible precautionary note that I will make about the microphones is apparently there have been issues of interference if things like continuous internet connection through 4G networks are being used. So if you do have something like a mobile phone tether link or a 4G wireless connection or something of that nature, and you are able to put it onto flight mode, that would be very helpful. So, as I was saying, ladies and gentlemen, we're very much at the bridge point now between strategic matters and matters of individual detail. However, there are two strategic matters reserved from the November hearings, and most of you sitting around the table here, of course, this morning, are here for the housing land supply matters reserved from Matter A, issues 2 and 3. Now, on the 9th of December, next week, there will be a session in the morning also to address land supply for residential institutions. And I do note here that we have Cooper Estates strategic land in the room, because I did just briefly wish to indicate the way I wanted to cut the business, so to speak. My intention was very much to proceed with all non-C2 housing matters this morning. I trust that was reasonably communicated in the agenda. And of course, Cooper Estates are more than welcome to take a watching brief on this morning's proceedings, and if there are general housing points that you need to make, be included in the discussion. But yes, there is interference again.
Are you logged into 4G or? Yeah, sorry.
No, turn it off.
Right, and then your laptop, is it on the right?
No, it's dead.
The irony, ladies and gentlemen, is that we had 2 absolutely problem-free days the last time we sat in this room, but I'm very conscious that most of the assembled cast here lived through the terrible nightmare of dealing with the microphones the last time we met. So let us trust that with now all wireless communication switched off, things run a little more smoothly. So yes, I was just briefly engaging with Cooper Estate Strategic Land. Does my mode of cutting that business strike you as fair? Have you got anything that you want to put to me?
Absolutely. We weren't intending to. We were coming on a watching brief, and could we thank you and the programme officer for allowing us to sit at the table, because we thought we would be sitting at the back. So, and we're here obviously if there's any matter to assist, but we're here very much as a watching brief, and we had understood the position as you've outlined it, sir.
Excellent. Well, in that case, we will proceed on that basis. Arrangements for today will break at approximately 11:30 for 15 minutes. We will break at 1 p.m. for an hour for lunch, resuming at 2. At approximately 3:30 p.m. we'll take another 15-minute break, and then again a 20 to 30-minute break, I would indicate, at around 5 p.m. because we are sitting on into the early evening today, and I will aim to conclude no later than 7:30 p.m. and indeed earlier if it can possibly be achieved. Now, can I just check? Nearly all of the faces, I think all of the faces sitting at the front table are familiar to me. There's nobody. Is there somebody? Yes, there are people here who haven't been in this room before. And can I just check, in terms of people sitting in the public gallery, are there people who've attended previous sessions, or are there people who haven't? There are people who haven't. Okay, well, I will just then run through a few more organisational issues about how the business of the day will play out, rather than assuming familiarity. The first thing I will check is with those of you sitting in the public seating. Apologies for its distance. That's just a matter of fact, given the room layout. Is there anybody sitting in the public seating who believes they should be speaking this morning on housing? No. That is very good to hear, so we don't need to adjust the seating at the table. The examination is of the Council's plan, so I will be inviting the Council to speak on every matter and issue in the agenda, and other than that, only representatives who've requested to be heard are entitled to speak. Papers that have been provided in advance have been read by myself and will be taken as read, so they don't have to be presented in principle. Discussion can move directly to the key points arising, taking the Council's and other representatives' positions into account. I will normally start the discussion of an individual matter by seeking involvements from the representatives, and then I'll move to the Council for responses. I may return to representatives for additional observations if the Council's contribution appears to require some response or open up new issues, but I will allow the Council the opportunity to make concluding remarks after any such observations. When you are asked whether you wish to speak on a matter, the traditional way of indicating whether you do is to place your Toblerone up on its end like this. That gives me a beautiful visual signal that you wish to speak on the matter. When you finish speaking and you believe your contribution is concluded, place it back again. And then, again, I have a perfect visual guide to the fact that you consider that your involvement is complete. Of course, if a point is then raised by another speaker that is relevant to your position, you may wish to come back in, but you never need to reiterate what others have said. It would be sufficient just to say, we support the previous point, if that is indeed what you do, and move on. Now, I'm conscious that we have a long and busy day before us. This morning's housing land supply business appears to be quite complex and likely to require all of the time that we have available. But I would say, in opening it, that it has already been carried over from November and been provided with extra time. And therefore, to be fair to people who are here for this afternoon's business, we must finish by lunchtime. Anything that we haven't got to by lunchtime will have to be reduced to writing, ladies and gentlemen. And I would strongly encourage all parties involved in this morning's business to do their best to use the available time well and avoid the need for any follow-on procedures. Can I then ask all of those who are speakers today, starting with the Borough Council, to introduce themselves? So, for the Council.
Kelvin Hinton, Planning Policy Manager with the Borough Council.
Adrian Toffs, Planning Policy Team Leader with the Borough Council.
Introduce myself, sir, although we're primarily observers. Gregory Jones, Queen's Counsel for Cooper Estate Strategic Land. And to my left, Robin Buchanan, Provision, also appearing on behalf of Cooper Estates.
Thank you very much.
Elizabeth Aikenhead for the Campaign for the Protection of Rural England, Tunbridge Wells District.
Thank you very much, Lady Aikenhead. The Civic Society.
Philip Whitbourne, Civic Society.
Brian Lippard, Civic Society.
Thank you very much, gentlemen.
Mike Pickup, I'm a planning consultant representing Gleeson Strategic Land.
I'm grateful, Mr. Pickup. If you could just angle your Toblerone slightly. Perfect. Excellent. I can now see everybody. Now, do we have another Toblerone in the far corner next to the Civic Society? Who's that? Countryside Properties. Well, they're not with us. Okay, moving on then. Persimmon Homes.
James Amos for Persimmon Homes, South East.
Thank you very much, Mr. Amos.
Matthew Evans, Gladman Developments.
Thank you.
Philip Scott, the Director at ACOM on behalf of Carnwood Estates.
Thank you very much. Now, just before we get stuck in, I've got 4 preliminary matters that I want to touch on, and then I'll provide an opportunity for those of you here to raise any preliminary matters. The first of those has already been disposed of. We are clear when Cooper Estate Strategic Land will be involved. The second relates to matters arising from site inspections that I carried out yesterday. Amongst other places that I viewed were the Knights Wood proposal in Royal Tunbridge Wells, where planning permission has been granted and Phase 1 construction is underway. Brief mention was made on site of a landscape and environmental management plan and a Section 106 agreement, which both had content relevant to the management of the effects of the development on ancient woodland and species in the woodland. What I would like then is for the Council at an appropriate time today to bring those 2 documents into the examination, make them available to the programme officer and put them on the website, essentially because the approaches being taken at Knightswood are potentially relevant to the way in which development might be managed in some of the other proposed allocations, and look, essentially give us a window into the cut-off line between matters that are dealt with in policy and matters that are dealt with through the development management process. Mr. Toffs, is that something that can be done?
Yes, sir, we will do that as soon as we get a break in today's proceedings. Yeah.
Excellent. Thank you very much. Now, moving then on to Paddock Wood, site inspections were carried out there yesterday as well, and one of the attendees on the Church Farm site was a gentleman, Mr. Corse, who is a written representative involved in this examination, but he has not hitherto requested to be heard. On site, he wished to refer to matters in his written submission, and I explained to him, as is normal, that other than confirming the location where the photographs appended to his submission were taken, that no submissions could be heard on site, but asked him to seek advice from the programme officer if he believed there were matters that he ought be putting to the examination orally. He has now made contact with Miss Duncan and requested to be heard in the Paddock Wood session. Does anybody have any significant objection to his involvement? No. Now, I'm conscious that Countryside Properties, who are interested there, are not here this morning, but all I can do is ask the question. It has been asked. Persimmon.
Yeah, sorry. So it's a Persimmon site, not a Countryside Properties site in Paddock Wood.
Right. Okay. Any objection?
No at all.
Okay. In which case, if I could ask the programme officer to communicate back with Mr. Corse and say that we'll be happy to hear him on Thursday. Only one other matter then in relation to Paddock Wood. The hearing, as I indicated, will be in the council chamber. I'd just like to check with the council. Do we have a sense of the levels of public interest and whether we need to make any different accommodation? Well, no, not security, I don't think. But I did say that I would monitor whether we needed to change accommodation for any reason.
Thank you, sir. We have tried to establish whether or not there will be a particularly large number of people attending, and the information we've received is that there won't, and therefore we're confident that we can accommodate our needs in the council chamber.
Excellent. Well, we'll stick with the agendaed arrangements then, unless anybody has anything else that they want to draw to my attention. Yes, we don't have quite the same draw. Are there any other preliminary or procedural matters that anybody wants to put in front of me before we make a proper start? Silence. So if we can then move on our agenda papers to the return of Matter A, main issue 2 and 3, general housing, 5-year housing land supply. We should now clearly be in a position where everybody's fully absorbed the implications of the Highgate Hill appeals. There's been a flurry of documentation as people have responded to that new material, and further housing land supply analysis, the Gleeson document that was tabled in November. An opportunity has also been provided to reach both common and uncommon ground on 5-year housing land supply. And what I would like now to reach are full and final submissions from all of those around the table, noting that there is still outstanding disagreement, so that I have absolute clarity on what I need to then take away and reason on. Now, what I would indicate is that I am not, for very obvious reasons, going to give you any extempore reasoning today. However, if it is my conclusion following a sensible consideration of what transpires today, including consideration of the points that you put to me orally, that there are further questions that I need to put to the council or procedural implications for the examination as a whole, then I will write to everybody involved in the examination, setting out the steps that I believe need to take place. So, with that caveat on the table, I will also place the caveat that we are very much still here in the strategic world, and so people who clearly do have interest in emission sites, if they could be put on one side and reserved until we get into the detailed part of the agenda, either later today or on the following days. So can I go to the representatives first and just see a show of Toblerones? Who wishes to speak? Gleeson? Canwood and Whitegate? Gladman? Not. Persimmon? Okay. Right. What I'm going to suggest that we do is that we start with Gleeson as essentially the the author of the tables that have been used to break down the analysis of performance that has become core to this discussion. What I'd like you, sir, to do is to take us back through the tables as they currently stand post the conversations that you've had with council, and then finally summarise and draw my attention to the matters of outstanding concern that you have, and then I'll do the same process whereby others will be able to just pitch back into the relevant component of your tables and make their own individual points. Once that's happened, we'll come to the council. So, Gleeson.
Thank you. There is in the documentation now a statement of common ground on the tables that were submitted to the examination on the 10th of November. That's document number TWBC/PS34. In that statement of common ground, there's some red changes which indicate differences between the original tables that are submitted and the tables as they're now agreed. There were two fundamental changes to some of the tables, not all of the tables. It's to do with the backlog. First of all, there was an error in the original tables in terms of the number of years of the plan that have passed, and the council have now corrected that to the 9-year period in, for example, row C in table 1. So we're agreed on that figure. The other difference initially between the council and Gleeson was how you calculate the buffer in relation to the backlog. In the original tables, the buffer, the 5% buffer, or alternatively the 20% buffer, was added to the backlog. The council don't agree with that approach. There was some debate between ourselves and the council prior to the agreement of these tables, and the council stand by their view that you do not add the buffer to the backlog. Gleeson actually maintained its view that you do, but to try and get to an agreed common ground, it was accepted that the council's approach should prevail because Gleeson could make the argument in relation to the tables whether or not you added the buffer to the backlog. Gleeson's case didn't change whether you added it to it or you didn't add it to it, but there is a difference of opinion there, even though these tables are agreed. The first four tables, tables 1 to 4, relate to the housing land supply position as at the 1st of April 2015, which was the original basis upon which this examination was brought forward, and the tables therefore are relevant to that extent. The tables show, table 1, for example, shows the well-known approach now, the Sedgefield approach plus the 5% buffer. The corresponding approach with 20% is table 3, and the alternative way of calculating supply, the Liverpool approach, plus the 5% and plus 20% are in tables 2 and 4 respectively. And incidentally, there's no difference of opinion in terms of the calculation in relation to the Liverpool approach. Now, because of the Hawkhurst appeal decision, it's Gleeson's case that you can no longer rely on table 2, which is the Liverpool plus 5% buffer, because that appeal decision suggested that the Sedgefield was the appropriate way of dealing with housing supply, that is to provide for the backlog within the next 5 years rather than spreading it over the entire plan period. Now, if you undertake that exercise, as demonstrated by these tables, tables 1 and 3, you come to a less than 5-year supply in both cases. If you take the Liverpool approach in table 4 and have 20%, you also come to less than 5 years supply. So there's only one table here, table 2, that credits the council with a 5.1 year supply. I think the council refers 5.11 year supply, but 5.1 year supply. But that specifically is the table effectively that was considered and rejected at the Hawkhurst appeal. The remaining tables show what the effect would be if you had a policy off fully objectively assessed need as the basis for your supply calculation, again based on Sedgefield and Liverpool, and with the options of 5% and 20% making up the 4 tables. Now, I believe that approach is relevant to consider because there will come a time in the near future when the council will have to form an opinion as to what the objectively assessed need is, not how they're going to meet it, but what the actual figure is. And therefore, at that time, the council will need to consider whether that's appropriate as setting the requirement for the 5-year supply. The reason that it's relevant in relation to the plan is that that could occur as soon as the next full review, as at the 1st of April 2016, which could be prior to the adoption of the allocations plan if it were to proceed. So those tables show what the situation will be, policy of, in relation to meeting fully objectively assessed need based on the supply as at the 1st of April 2015. In all 4 cases, there's a very, as might be expected, a very significant undersupply in relation to the 5-year requirement. At the examination hearing on the 10th of November, the Council then announced, and it seemed appropriate at the time, that the base would be updated to the mid-year 1st of October date. Now, the Council put forward their revised schedule based on that new date, the 1st of October 2015, and have come up with a surprising and very significant increase in the assessed supply and the number of completions that will come forward. Now, that increase has not been achieved by planning permissions. In fact, if you look at planning permissions, even including the Hawkhurst appeal decision, the number of permissions has actually reduced. The reason that supply has been increased is by 2 specific sites, the Paddock Wood site and the site in Tunbridge Wells, that's RTW4. RTW4 for 130 units, the Paddock Wood site for 427 units, giving you 557 units in total. So in the space of 6 days between the last examination hearing and the date the Council's figures were circulated on the 16th of November, there was a sudden dramatic increase in anticipated completions of 557 units, and that's over 110 units during each of the 5 years just on those 2 sites. Now, our concern is there's 2 elements of concern. Firstly, you haven't got in front of you a full mid-year assessment because that doesn't include any completions. So you don't know the rate of completions between April and the 1st of October. So that, as I say, that table doesn't, the revised table produced by the Council does not give you a full picture. And secondly, there's been only limited evidence as to whether the 557 units on those 2 sites will be delivered as completions within the 5-year period. And I think that lacks credibility. And for those 2 reasons, we would ask you to consider, Gleeson would ask you to focus on tables 1 to 4 of the Statement of Common Ground as being the correct position to look at, the full information you've got based on the 1st of April 2015, but also bear in mind the potential for the change to the supply calculations once objectively assessed need has to be taken into account. And the fact that this plan, at the moment, we would argue, looking at the Sedgefield plus 5% or Sedgefield plus 20%, cannot deliver a 5-year supply, and certainly it can't deliver a 5-year supply if you start to look at objectively assessed need. Now, I know that the Council will say that's not the function of this plan, but in terms of outside of the plan and dealing with Section 78 appeals, very clearly developers are going to say, what is the housing land supply situation? You've got a non-compliant core strategy having regard to paragraph 215 of the framework, and how much weight can you attach to the core strategy based on an outdated South East plan requirement, and now a site allocations plan that is based on that outdated core strategy and cannot deliver a 5-year supply, certainly based on the 1st of April 2015. And that, I have to say, is the agreed position of the Council if you take tables 1 and 3. I think essentially that's as far as I want to go at the moment. I'll let others have a chance to add to those comments.
I'm grateful for that precise but concise summary of the position. I mean, what I will flag now, I'm not asking the Council to respond now because I'd like to hear others, but the two key issues that are emerging for me from the analysis and discussion so far are as follows. Firstly, in terms of the Council's recalculation as set out in paper under reference PS 37, how account is taken and whether indeed account needs to be taken of new completions. That's one issue. Second, and at the moment weighing very heavily in my mind, is essentially the very practical set of considerations around confidence in the particular delivery of additional dwellings from sites such as ALRTW4, Eridge Road, Area of Change, or ALPW3 with the Ryden and Persimmon land at both Church Farm and Maskell's Court Road. And apologies in that respect, Mr. Amos, it was Ryden homes that I was referring to, not Countryside. I muddled myself briefly there. And in that respect, Mr. Amos, I did want to check. I know you're sitting out this, but do you attend with a brief to give your client's side of the story in relation to the scale of delivery on a site that suddenly becomes, it seems, quite critical to the achievability of the Council's case?
Thank you, sir. Yeah, I was sitting out initially just to hear the comments made by my colleague to the right, and you're absolutely right. I am here to hopefully give some confidence to what we think can be delivered from our site at Paddock Wood. So perhaps I'll allow the others to speak first and then come on after that.
In doing that, of course, we'll have to put somewhat of a caveat around that because the specifics of Paddock Wood itself have not yet been examined and will be. We will come to that. So I'm going to have to bring, 2 spacecraft into synchronized orbit and dock them after I've heard these arguments today and those arguments on Thursday. Thank you very much for that. Can I then move on to Gladman?
Thank you, sir. I think this will be relatively brief. I think I'm largely in agreement with my colleague from representing Gleeson. The key issues for us really are, firstly, the buffer in terms of where you apply that, and we've provided you with detailed submissions, so I don't intend to elaborate on those further unless you wish me to. Conscious to say that I could probably give you another 15 or 20 decisions which reflects the ones that we've put into our statement as well. The base date, as you yourself have flagged up, is a difficulty, and you'll remember that I expressed my concerns about that when we sat here previously. It is an issue that's cropped up a number of examinations, and it is difficult, and I accept that it's difficult for the Council to do that, but it is very challenging to create a 5-year land supply position without a proper base date. And when that proper base date doesn't include all the information, I do have concerns about the robustness of the figures that you arrive at. And again, in our statement, you'll see my reasons for doing so. But one of those reasons has to reflect the position you might take on the 5 or 20% nature of the buffer to be applied to the figures. And when you start using incomplete data with no completions, that can potentially become a problem, especially if And I will admit in this instance, the 5 and 20% buffer in this instance is debatable. We are of the view that it's 20%, but the council are of the view it's 5%. And I understand the reasons why they do take that view. In terms of, again, I don't think I've got much to add to my colleague. We are, again, last time I referred to us being in a bit of a bubble in this examination in terms of what we can and cannot achieve in terms of the housing requirement. Whatever we decide, if we use that 300 figure, it's relevant to this examination only. It's not relevant to the real world in terms of the determination of planning applications. And one of the key issues we've had in trying to get to the bottom of the 5-year land supply here, and this is something that's a problem that's likely to grow as the requirement for this district grows in the future, is that within the council's statement and information, there is no detailed breakdown on their assumptions of how they've arrived at their position. So we don't know what assumptions they've made in terms of lead into site delivery, how long they've allowed for example, getting reserved matters, Section 106 agreements, discharging conditions, the amount of units per annum which each site is expected to deliver. We would expect to see a breakdown of each site within the 5-year land supply on a 1, 2, 3, 4, 5-year basis, showing 20 units per annum, 30 units per annum, however many it may be that the council thinks is achievable, and evidence for demonstrating that. And that is fairly normal practice, we would argue, in arriving at a 5-year land supply calculation, especially as part of an examination where it is a requirement to demonstrate a 5-year land supply for that plan to be sound.
In that respect, would it be your view as well, given that one of the things I've got to deliberate upon now is this rebasing, that the rebasing in and of itself requires greater evidential diligence to actually demonstrate that it is, robust?
It is. I personally don't think you can rebate unless the council knows exactly what the position is on every element of the 5-year land supply, from permissions to expirations to completions, everything. Then you should stick with when you've got the last set of complete data. So if that last set of complete data is the 1st of April, then that's the date we should be using. We shouldn't be shifting half a year with 3/4 of the information or half of the information or however much it is we've got.
Okay. Right. Well, I hear very clearly your position. Canwood and Whitegates.
I would like to say our position is simple, Mr. Inspector, but it isn't. It's a mess. It's a mess and an invidious position that you've been placed in. I think it's an invidious position that senior officers have been placed in, because I can only imagine it's members who are directing officers to take this stance. Less than 8 weeks ago, your matters and questions were answered by the council, and there has been an absolute sea change, a complete sea change since that first statement was released by the council. They said, effectively, we have a robust case. We have 5 years and 1 month worth of land supply. We're good, Gov. We're fine. The good ship Tunbridge Wells sails well, and all is well in the good ship policy Tunbridge Wells. Since then, they've been holed under the waterline. They've been torpedoed. That torpedo is the Highgate Hill appeal, and the Highgate Hill appeal has changed the world and their ship. And because of that, they now tell anyone who wants to listen that they now have up to 6 or 7 years worth of land supply. They've provided a very cursory breakdown in a matter of 2 weeks that they've suddenly found near on 600 units, 427 of which go on to greenfield land at Paddock Wood. Persimmon and Ryden must have the fridge full of verve at the moment. They must have thought their numbers had come up. Well, good on them. I'd certainly be giving evidence to this inquiry that it's achievable. Good God, I mean, you'd be out of a job if you didn't. But there is a third point, Mr. Inspector, that you should be considering, and you've raised 2 issues. The one is the desirability of loading 5-year housing land supply at Paddock Wood, which is a third-tier strategic settlement. And how does that accord with the core strategy and previous strategic policy of facilitating Tunbridge Wells as a regional growth hub? We say that it doesn't. We say that that's absolutely erroneous and it's perverse. It's even more astonishing when you think that loading Paddock Wood with all of this development is actually in advance of your deliberations on whether Paddock Wood is the right place to load such development. And given the flooding and flood risk issues, and given the amount of public disquiet about loading development there, we have no issue whatsoever about Paddock Wood taking its share. We have no issue with colleagues to the right of me and their requirement to build housing, because this is about meeting housing need in the borough. And what has become apparent over the last 6 years, and unless we forget this, ladies and gentlemen, we're not here to play a game. We're here to meet housing need by people that absolutely need a house in this borough. So your daughters, your sons, your children, your children's children need somewhere to live. This isn't a game, and yet it's being treated like a game. And in 6 years, housing need has more than doubled. If we load housing in some of these locations which are as yet untested, no planning permission, with a planning application, a hybrid application that's been in the system for 12 good months and hasn't moved, there's a question for the council. Why has it taken 12 months for an undetermined application at Paddock Wood? I can quite foresee 427 units taking another 2 to 3 years to secure
I trust
detailed
427
consent.
units, not years.
Oh, sorry, 427 units. It's going to take years. That's without judicial review. That's without appeals. That's with detailed planning permission. That's with building regulations. That's with site preparation. But it's not just the credibility of the rate of delivery. It's the desirability about loading 5-year housing land supply in a third-tier settlement, when the bulk of that should be going, new development should be going in and around the LBD of Tunbridge Wells. A promise and an assurance and an acknowledgement of which was made both in the core strategy and in the various parts of the evidence base, both in the 2009 SHLA and in the March 2013 iteration of the SADPD, and at paragraph 233 of the DPD, that the council would look at releasing sites in and around, i.e. contiguous with the LBD of Tunbridge Wells. And yet nothing has been done until about 10 days ago, when we're told that over 400 units will go on greenfield land which is subject to flooding and flood risk at Paddock Wood. So it's not just that, for us, it's not just that we doubt the rate of delivery. It's that we have serious concerns about what the objective assessed need should be. We have serious concerns about the amount of credible data that's in front of you. And we do not believe that it is desirable for that amount of units to be placed at Paddock Wood. Thank you.
Thank you very much. Well, again, there is an overarching question that emerges for me from that, which I want to add to the two questions that I drew out of the combination of the Gleeson and Gladman contributions. And that essentially is to return to what I can only refer to as the strategic balance, and to look at, respectively, Core Policy 11, which governs broadly the volume of housing to be delivered at Paddock Wood, with Core Policy 9, Development in Rural Tunbridge Wells. Because, in a nutshell, for Canwood and Whitegates Farms, I see that as being at the heart of your submission, that you believe that the strategic balance is wrong, and that you believe that there is a core strategy delivery, a core strategy compliance issue, because essentially too much is being loaded into a location which, in your view of the core strategy, shouldn't be.
It's just a question of just too many eggs in too few baskets. And if anything happens, and I accept that Persimmon and other parties will say that they are confident that they can deliver that number of units within 5 years, well, they would, wouldn't they? And I would be doing that if I were in their position. But setting to one side the individual merits of individual cases, it surely can't be desirable, given where we've got to in 6 years, that we're in this position where the council is so desperate to find this plan sound that they start throwing, well, just add 130 here, just add 427 there, that we're moving forward with putting too many eggs in one basket. And if there's something happens, something that we can't foresee here on a site which doesn't have planning permission, you're in even bigger trouble moving forward than you currently are.
Thank you very much. Now, I'm just briefly checking a couple of matters that relate to the way that we will move forward. Yes, I was just checking that we do have Ryden as well as Persimmon due to be heard on the Thursday morning, because what I'm essentially trying to resolve in my mind is the best way of, I guess, discharging the evidential burden that's being placed upon these sites, noting clearly that we have Mr. Amos here, but Mr. Amos speaks for half the story, not the whole story. So there will be a need to review that position very closely on Thursday, and I suspect, Mr. Amos, the best thing for me to do will be to have that discussion with both of you on Thursday, in order that it is complete and that the read across between the two sites is dealt with properly and fairly. I think if we proceed on that this morning in any measure of detail, then we'll only end up having to do it again on Thursday in any case. Right. That being said, I am now looking at the time, and I did indicate when we started the time of break at 11:30, but I am conscious that Council need to draw together the position from the three main submitters here. So I'm actually minded to call a break, a 15-minute break before we actually hear the Council's in-principle response to that which has been put just. However, before I do, we have two Toblerones. So if I can go to Gleeson and then to Persimmon for your points before we break.
Yes,
just something
I wanted to add. The rate of anticipated completion set out in the Council's statement, PS 37, on page 4, table 3, you've got an estimated breakdown of completions on an annual basis over 4 years for site PW3, but you've got no breakdown that I can see for the 130 units on RTW4. And so I haven't seen any evidence of where the information about any sort of assessment of completions the next 5 years occurs on that particular site. And it may be that I'm missing something, and perhaps the Council can just respond to that point.
Indeed. Thank you very much. Persimmon.
Thank you, sir. I agree that we should talk about this more specifically on Thursday in the Paddock session, but I just didn't want you to go away with the view that Mr. Scott was representing house builders in particular, and some of his comments about Persimmon would say that, wouldn't they?
You've got an opportunity here to
exactly.
respond to that.
I do want to emphasise that Persimmon are fully involved with the council in getting this application at Paddock Wood determined. It is a hybrid planning application, so we are hopeful that permission will be granted on the Paddock Wood site early in the new year. And we have been talking to the council about the committee dates, and they were held back to allow these hearings to take place. That's why no decision has yet been taken, because obviously the council need the assurance that their site allocations document will be taken forward at the same time or in parallel with the planning application to give everyone the certainty that the housing will take place. So we are confident that the decision will be taken in 2016. Yes, there will be a delay until construction actually takes place, but as I said, it's a hybrid application. 175 of the units will receive detailed planning permission, subject to discharge of conditions. We would anticipate construction starting at the end of 2016, with units to be delivered mid-2017. So Table 3 in the Council's position statement is perhaps a very conservative estimate of what could be delivered from our site. I would say that we will get at least 30 units out in 17-18 period, possibly more. 60 units per annum is a conservative estimate. That just over averages 1 unit per week, but a site like Paddock Wood could possibly deliver more. On that basis, there is a very good chance that this site will deliver units within the timescale anticipated by the council. Thank you.
Thank you very much for that observation, but of course, as we've discussed, that doesn't absolve us from needing to go into the detail on Thursday. Ladies and gentlemen, it is now 2 minutes to 11 by my computer clock. I'm going to suggest we break for the full 15 minutes after 11, so we return at 15:15, and then I will give council their run at what we have just heard, and we'll be exploring it further. Thank you very much, ladies and gentlemen. Now, before I ask the council to summarise their position and then to respond to the issues that have been raised by essentially the house builders to my right, I do notice that CPRE have their Toblerone raised, and I was also just briefly going to check before we hear from the council as to whether or not we'd heard a contribution from the Civic Society as well, because I would like to draw anybody who has oral contributions on this in before asking the council to put their position so that they are able to address the entire set of arguments rather than just house builder arguments. So if I can go to Lady Aikenhead.
Thank you, Inspector. I'd like to say that because nobody else has said it so far, just to point out that the decision of another inspector doesn't necessarily make the law. It hasn't been tested in the High Court, that particular decision. It's obviously not going to be. So although there is some advantage in consistency, no doubt, in inspector's decision, you are completely at liberty, so far as I'm aware, to make your own decision on what the law is and to take it from there. Addressing the issue that the gentleman for Canewood and Whitegates Farms was saying about balance, different sites in the course of a plan naturally come forward at different times. You don't always get all the sites in one, you don't necessarily get when you've got some big sites or even some smaller sites, they don't all come forward in the same places at the same time. And it's quite natural for the Paddock Wood sites perhaps all to be coming forward at once, particularly since there is this infrastructure need which the sites will all be trying to address, or we hope they will. In any case, there are various large sites that have already come forward and been banked, so to speak, in Tunbridge Wells, along with a great many small sites. For instance, the Kent and Sussex site. I mean, there's no mention in the forward stuff about the Kent and Sussex site. That's already going ahead. So the idea that the whole balance of the core strategy is being skewed by putting the housing at Paddock Wood is, in our view, completely wrong. We agree with the Council that they take a very conservative view on the likelihood of completions. We can see from the tables that they've submitted, for instance, that they don't include Maskell's Farm at Paddock Wood or the Crane Valley at Cranbrook in their 5-year housing land supply, that table that they've produced as sites identified. I'm sorry, I rather lost where exactly that table came from, but maybe the Council can find it for me. But it is on Tunbridge Wells Borough Council paper, so I assume it's from them. And we would argue, indeed, on the figures that the Council has put forward, that there's going to be such an oversupply over the total period of the plan, that the Crane Valley site indeed won't be needed. Thank you, that's enough.
Thank you very much. I'm just briefly finishing my note, and then I will turn to the Civic Society. Okay, the Civic Society.
Thank you, sir.
Lady Aikenhead, if you can just put your Toblerone down, and then I won't come back to you.
There's been quite a lot of mention of RTW4, and I would just like to put down a marker that is a highly sensitive site at the very end of the Pantiles, which of course is Tunbridge Wells' famous and important tourist and other attraction. Historically, it's the most important bit of Tunbridge Wells. So this very sensitive site at the end of the Pantiles, RTW4, it has at the moment an unattractive building called Union House on the site. That's recently been bought by Dandara, who've gone public recently on their ideas for redeveloping it. We in the Civic Society would be very keen to see something better than that which is currently proposed, but at the moment there isn't a planning application, still less a planning approval, unless the Council have gone a lot further than we think in indicating to Dandara. We had a meeting with Dandara yesterday. We expressed various reservations about their scheme as it stands. At the moment it's 8 stories high, which is quite a large building in Tunbridge Wells terms. So just putting really down a marker that this is something that may well be possible in some form or other and may well be desirable, but it's got a long way to go as yet. What we wouldn't want to see is the scheme sort of bulldozed through the planning process to meet housing numbers. That would be a wrong way to go about things.
So to look at this in the round, would it be your position then that there is a need for additional land somewhere in order to essentially take the strain and allow that site to proceed in the measured manner that you would consider as being appropriate.
I think what we would like is the scheme as it stands proposes leaving the surface car park behind Union House as it is. We would like to see an extension of the residential development over part of that car park, keeping all the lime trees and so on set back from that, so that you can reduce the 8 stories to something a little more in scale with the Pantiles. There are also architectural issues. We don't like the appearance of the building from the Pantiles, but that's something that could be sorted out architecturally as distinct from the planning issue of disposing the mass in a seemly way.
Okay. Right. Well, in which case, I think we've come to the conclusion of oral submissions from broadly this side of the table. So I will now turn to the council. Who's going to lead on this? Mr. Hinton. Okay. Could you initially, I guess, take me through your primary proposition, which, as I see it, is set out in document number 37, PS 37, the position statement on 5-year housing land supply, and pick up and respond to the matters that have been put as you go.
Thank you, sir. If I may, I might just start in a slightly different place in terms of where we actually started the discussion this morning, and that is the set of Gleeson tables, as they've been fondly referred to. As you heard and as you've seen, the tables are agreed in their revised form. There's 8 tables in all. Tables 1 to 4 set out various scenarios based on a position of the 1st of April of this year. However, as you would have seen from the Council's statement, PS 37, we believe that the position has moved on since then, and we set that out in our statement and the various information that's been referred to by others around the table this morning. So those tables are agreed, but if you like, we take the view that they are now a historic position. Things have moved on, and you need to make decisions based on situation, the most up-to-date situation today. The other tables, tables 5 to 8, as again you've heard, refer in part to the OAN figure, which has come from the SHMA. And as we discussed at the initial hearings, and as Gleeson, I think, accepted when they were addressing you, it's not for this examination to look into the future and predict what might or might not happen as part of the local plan review. So, as interesting as those figures are, again, I think they're not necessarily relevant to the key issues for this examination, which is whether a 5-year supply against the core strategy target is in place. Gleeson also, in talking about the OAN, we're talking in the context of a Section 78 appeal. And the starting point in the Section 78 appeal, as we know, having regard to the advice in the framework, is different to the considerations that you have to give based on the core strategy and the allocations against it. So again, I think that lends to the Council's case that, as interesting as those figures are, they're not really for today's examination. Moving on, as has been referred to and is set out in our statement, we have presented what we consider to be a revised position as of the 1st of October of this year. I think everybody can agree that a particular 5-year position is always a moment in time. As CPRE have mentioned, it's not an absolute constant. Sites drop off a list, sites come into a list, permissions are granted, applications are made unexpectedly. It's always a moment in time. I think it's also fair to say that when we presented our case at Highgate Hill, we felt at that time our case was robust. Clearly, the inspector disagreed with certain of our positions, and that was weighed in the balance in reaching a decision. So I think it's only fair that the council should review its position and present what it believes is the most up-to-date and robust case that it can. Why wouldn't it? We've heard that developers are always keen to talk up their sites. In my experiences, objectors are always going to cast doubt on the council's position and rarely agree with it. The information that forms the basis of our revised position, and it's quite clear and accepted, that the main change relates to certain sites which, based on the most up-to-date information we have with those developers and promoters of that site, those sites, gives us confidence that those sites which are promoted as allocated sites, they're not new sites which have come out of the ether from nowhere, they're all sites that people know. The most up-to-date information we have from those parties is that those sites will come forward sooner than expected and will make a contribution to the housing supply. And as we all know, the approach of the framework, and in fact people around the table is promoting that the council should be more proactive in its delivery of housing. So why wouldn't we do everything possible to deliver those sites as soon as we possibly can, faced with the criticism that is being made against us? And also, so as you've already pointed out, the promoters of that site, of those sites, are due to appear at this examination at some stage. And just like Persimmon, you will be able to hear from them exactly why they are so positive about their proposals and the delivery. The information that we've had from those developers, nonetheless, has been moderated to some degree. So the figures which are set out in Table 3 of our Statement 37 are moderated expectations. We haven't just taken the figures supplied by the promoters of the site of Paddlewood and repeated them verbatim. We have moderated them. And that reflects the approach that we have always taken to sites and information making up the 5-year supply. We always take a conservative approach, both in terms of the site yields, applying a 10% reduction in certain cases, being conservative on the capacity of those sites. So I would say on behalf of the council that if anything, our figures are always on the lower side rather than the higher side. And the moderated approach to the Paddlewood expectations continues that theme. We have been criticised about the implications of taking a midpoint throughout the year, and we accept that. However, we felt it was appropriate to present you with the most up-to-date information based on sources that we have. You will see in those figures that we've built in a non-delivery of half a year. So if anything, we're doing ourselves a disfavour and doing a favour to the objectors. So again, the figures, whatever criticisms you apply to the maths, favour the objectors rather than the council. However, we have still tested all possible scenarios, whether you take the Liverpool or the Sedgefield approach, whether you take the 5% buffer or the 20% buffer. And in our revised position, all of those scenarios still achieve a 5-year supply. So even if you go with the worst case scenario, which is promoted by the objectors, a 5-year supply is still in place. Finally, sir, you've also received comments about Paddock Wood and how our promotion of sites there somehow goes against the grain of the core strategy. The core strategy actually identifies Paddock Wood as a second-tier settlement, not a third-tier settlement. The council's position is that in promoting those sites at Paddock Wood, we have promoted a sustainable form of development, which not only complies with the core strategy objectives and strategy, but is fully in compliance with the NPPF as well in that approach. And as we all know, the promotion of sustainability is at the heart of the framework. Finally, sir, in talking about those emission sites that are being promoted, it wasn't mentioned that the key sites that are being promoted are actually in the Greenbelt, and what the implication of that designation is in terms of how you could consider them and how they sit in being acceptable in the overall scope of the plan. That wasn't mentioned earlier, and I think that's important to bear in mind that they are Greenbelt sites. Thank you.
Okay, can I just explore some of the issues that have arisen there? I guess that the first issue that I want to explore, without trespassing too much on the necessary discussions for Thursday and Paddock Wood, and indeed for this afternoon, in relation to the Eridge Road site. I guess what I'm looking for here is a sense of what has underpinned your change in the assessment of the timing of delivery of the particular sites at Paddock Wood and in Royal Tunbridge Wells, the Eridge Road area of change, that has meant that only a few weeks ago those sites were not included within your base calculation of a 5-year housing land supply, and now they are. Now, I've heard what you've said in terms of, the view that you've received from developers that, that there are sites that can be brought forward reasonably quickly. And they're very different sites. So probably the best place to start is Eridge Road. Just take me through the reasoning process that the path that you have followed to lead you to the view that you can deliver 130 dwellings within your 5-year housing land supply out of that particular site.
I think the first, in setting a context, it's not a situation where this site is suddenly parachuted in on the 1st of October. The site has been promoted as an allocation. There's been discussion all along. And to that extent, the council could have been reckless and included it within the 5-year supply at a sooner date and probably be criticised about that. We're being criticised now, but our position is based really on the extent that the site has been assembled by the party promoting it, the fact that we're advised that the last tenant's lease expires in August of next year, the advanced stage that the pre-application discussions, which have been going on for some considerable time, to refine a proposal which we hope, when submitted as an application, will be fit for purpose and achieve what we want to achieve on the site. Those discussions have been very positive to our way of thinking, to the extent that The promoters have undertaken a recent consultation and are looking to submit an application very early in the new year based on those pre-application discussions. Further to that, we've also had discussions with them in terms of what their programme would be, in terms of when they would look to start demolition, the construction phase, and when they would expect first units of occupation on the ground. And obviously in that particular scheme, it's a flatted scheme, so the scheme is likely to start and the build is going to continue until the building is finished and fit for occupation. So it's slightly, or it is quite a lot different to a greenfield site at Paddock Wood, for instance. But it's a combination of all those things which lead us to believe that it is appropriate to include it in the 5-year supply based on a review at the 1st of October.
And those all take into account the issues that, for example, have been brought to the table by the Civic Society. It's a site that affects the setting of listed buildings. It's a site partially within the town centre conservation area. It's a site with a large, I assume, concrete frame pre-existing building, the demolition of which will be a fairly substantial engineering undertaking in and of itself. All of these factors have been brought to bear, and if necessary, additional evidence could be brought in that actually draws that material out.
In the simple answer, yes, sir. We could put that in additional written representations if you wanted to. I can confirm that the council has put a considerable resource, both in terms of a major projects planning officer and the council's urban designer and the council's conservation officer in those pre-application discussions. They've been ongoing for some considerable time. We believe they've reached their natural point whereby the developer promoter can have confidence to submit an application which is fit for purpose and which achieves what we wish to achieve for the site, both in terms of the uses and the quality of the development.
Okay. I mean, my reasoning for asking that last question will I trust be apparent in that essentially, what I'm being asked to entertain here is a fairly substantial rebasing of the mathematics that underlies your position, and clearly I think there is a need to get the evidence base that supports that rebasing on the same footing as the earlier material that others in this room have clearly spent, a number of months living with, lived, breathed, understand, disagreed with you on, but, probably don't challenge you as to veracity, evidential veracity. And similarly, I think in terms of the diligence that I need to do in considering the case that you're putting forward, I feel a need to see some more entrails, if you don't mind that slightly strange.
That's fine, sir. We can draft an additional paper which sets that information out. I'm clear on the information you need.
Yeah. And so then, very, very different sites. But, and again, without covering the detail that we'll need to cover on Thursday, you'll be conscious that I'm going to ask you again for the same sort of evidential background in relation to Church Farm and Maskell's Court Road, because again there, I guess my starting point question is, if those sites were so deliverable on the timescales that you set out in Table 3, then there is a kind of underlying question in my mind as to why that wasn't something that was set out in evidence to the first deadline, and then we could have proceeded on that basis moving forward, even though that would have been a different position from the one that you set out in your appeal statement to the Highgate Hill appeal. Now, I guess here hindsight is a glorious thing, and it may well be that your view was that you didn't need to go that far. But put it to me, why were those cases? Why were those sites rather not drawn out in earlier evidence?
I think so. It's similar reasons. I'm conscious of two things. First of all, not to give the impression that the council acts in a way where all these things are absolutely a done deal and the planning application process has no purpose to serve. I accept that, and that to a certain degree that until a permission is in place, those wishing to cast doubt will cast doubt. However, in the case of the Paddock Wood sites, again, we've had considerable pre-application discussion with the two promoters that we now include in the supply. There is a third promoter, which we haven't brought into the frame, but is equally confident about when they might submit a planning application based on the pre-application discussion that has been happening. So in the two sites that we're referring to, there is a long history of pre-application discussion. I can tell you that discussion has sought to address all of the issues for the site, particularly in terms of flooding, which is the issue which is most commonly raised by the local residents. And sites like that will take time. In my experience, it's not unusual for a site of that nature to be on the board, so to speak, for up to a year. I could point to many examples of that. It doesn't mean that the dialogue hasn't been positive, and it doesn't mean that delivery of an application of a permission isn't achievable in the very near future. As I said, in respect of Union House, in terms of the Paddock Wood sites, we could have introduced them earlier. We would have been criticised. We would probably have been criticised to a greater degree than we've been criticised today. But we feel, in reviewing our position, reviewing our case as of the 1st of October, it is appropriate to include them at this stage. And we're positive, based on the discussions and the programme expectations that those developers have given us, which we have modified and moderated in our statement, that all gives us confidence in including them in our revised position statement, sir.
Okay. So then, setting the Arid Road area of change site to one side for a minute, because nobody's suggested that there is a core strategy compliance issue with that site, or if we look at the two Paddock Wood sites, and we've had put to us in fairly strenuous terms that somehow the local planning authority is stretching a point in terms of compliance with Core Policy 11 by loading additional development early on into Paddock Wood and essentially pressing it beyond its strategic function as set out in the core strategy. Now, you've set out in the submission that we've just heard orally and in writing, it's your view, Paddock Wood is a second tier, not a third tier settlement, and so in broad terms is appropriate for the function that you're proposing for it and the level of housing delivery that's proposed. I do just want to take you back to Core Policy 11 and essentially the balance of delivery there between the volume of housing proposed to be brought forward at Paddock Wood as against the volume of housing to be brought forward in Royal Tunbridge Wells itself. You've given me a very simple view, which is that you think there isn't a strategic compliance issue, that you're content that the volume of delivery at Paddock Wood is within core strategy. Take me through that story in a bit more detail, please.
I think the starting point is probably to be completely acknowledging of the fact that obviously the figures in the core strategy, it refers to 600 at Paddock Wood rather than the 900 that we're now promoting. So clearly the figure has changed and the figure has gone up. However, the site allocations plan is and has been prepared in the context of the National Planning Framework, which has an underlying thrust of the delivery of housing at its core, and in those terms the Council has to look at how it can meet the housing needs of the borough in the plan. We are not looking ahead in terms of the local plan review, so there is this balance between adhering to the core strategy, but also complying with the framework as the up-to-date national policy. The overlap between the two, the core strategy and the framework, is this golden thread of a sustainable form of development. Both documents talk about that, and we believe that the approach that we've taken in the sites allocation, as I mentioned earlier, achieves that, and that the allocations at Paddock Wood are based on a sustainable development strategy. Paddock Wood is identified as a second-tier settlement. It's the biggest of the second-tier settlements that are referred to. It benefits from many aspects of sustainability in terms of, for instance, having a railway station, having a town centre. It's not constrained by the green belt. It does have constraints, but the Council has fully assessed those in promoting the sites and in pre-application discussions. So we would say that promoting the level of growth that we are at Paddock Wood isn't fundamentally against the strategy of the core strategy. It's fundamentally in compliance with the NPPF and would deliver a sustainable form of development.
And again, looking to the merits of a possible alternative detailed approach to implement the core strategy, which might have been to deliver more sites in and around Royal Tunbridge Wells and Southborough themselves, which is the strategy that's being urged on me from some on my right. Take me again to the detailed strategic rationale for not so doing. I mean, you've made a brief summary comment to the proposition that the alternative sites that are being promoted are greenbelt. Essentially, that the feeling that I get from the materials I've got in front of me in your oral submissions is of a view of the world in which because you have not undertaken to review Greenbelt per se within this allocations plan process, you therefore don't see yourself as being able, in terms of the compliant with the core strategy, to do that sort of work, and it would be that sort of work, in your view, that would be necessary to deliver significant additional volumes of land around Royal Tunbridge Wells and Southborough. And as I see it, you're telling me that that's a job for the local plan review, and you don't see yourself dealing with it within this process.
Exactly, sir. The sites that are primarily being promoted are Greenbelt sites. We haven't undertaken a Greenbelt review as part of the preparation of this site allocations document. That is a matter that will be reviewed as part of the local plan review, and therefore, as we set out in our statements and as you've summarised in your comments there, we feel that against that background, it would be wrong and beyond the scope of the work that we've done to release Greenbelt sites, particularly having regard to the advice in the MPPF regarding Greenbelt releases and how to conduct Greenbelt reviews. As always in planning, time marches on, but the MPPF does obviously post-date the core strategy and what it says there about Greenbelt. So that is the Greenbelt position. But there is another point, is that, as I mentioned earlier, our approach to delivery of housing from Tunbridge Wells and Southborough is conservative in terms of the capacity, the deliverability. We have consistently taken the lower yield figures from the sites. We've taken a conservative windfall position. However, recent evidence through pre-application and applications shows that on a number of sites, proposals are coming forward for numbers of units which exceed what we expected, and they are being found acceptable development and granted planning permission. So I think the contribution from other sites is equally important as the Greenbelt position.
I hear what you say, but again, the slight dilemma that I've got in relation to that last point is an assertion that a set of figures are inherently conservative is an assertion. If it's going to be relied upon again, we probably need some sort of evidence base that actually says, well, here is a sample of delivered sites within Royal Tunbridge Wells and Southborough, or indeed across the borough as a whole. These were the original site yield assumptions that we made, that we plugged into our housing land analysis for AMR purposes over a given number of years. And this is what actually came out at the end. And it's a lot bigger. The margin is X. The margin is Y plus. If that evidence is reasonably easily available, it helps to make the clear point that these figures are conservative, and it actually increases the confidence level that can be ascribed to these figures. Does that make sense as an in principle position?
It does make sense. I'm trying to present the council's position as a balanced position. I don't seek to produce a table which says, based on that conservative approach, here's another 200 units. All I'm saying is that the council approach needs to be weighed across all aspects. We've been criticised for our approach. But nobody has criticised our conservative approach to those figures. Nobody said that's the wrong approach. No one's saying that we may actually get greater yields from some of those sites.
With respect, it's not in their interest to say that to me, because at the foot of their presence in this room is an argument that they've actually got some wonderful sites that they would really dearly love you to consider additionally over and above the sites that you're currently promoting in this plan. So I wouldn't expect to hear that argument from that side of the table. However, sitting neutrally in between the two sets of arguments, I'm trying to work out what I need to take away with me to carry out a fair and balanced evaluation of the arguments that have been put on this side of the table and the arguments that are being put from yours. Hence the feeling that if I'm going to give credit to the proposition that your figures are conservative and essentially allow a margin above them as being a likely achievable yield, then some more evidence would be useful. Alternatively, I could take a kind of reductive approach, which is that the figures are the figures are the figures. What I'm going to is that a point specifically on this point?
It is. I think I completely agree with what you said. I think, to be fair to this side of the table, or to be fair to Gladman in particular, we have made that point, perhaps trying to get the other way, admittedly, but we have made that point about the transparency of the Council's figures and the assumptions which underlie it and the fact that they're just not there to be commented upon. True.
And apologies to you because you have. Let's just give the Council some space to carry out the team consultation that's happening right now. I do see all of your Toblerones. I've got a line of questioning that I want to pursue to its bitter end. I'm then going to ask the Council to essentially put their proposition to me after that. We've got plenty of time this morning. We're not due to break till 1 o'clock. I'm then going to come back to this side of the table and ask for essentially responses to what you've heard, noting that we're in a dynamic set of arguments here, and then I'm going to go back to the Council again. Gleeson, very briefly.
Yes, just briefly, matter of procedure. I was assuming that the Greenbelt allocation, non-allocation would be a matter for tomorrow and not today, so I specifically didn't raise that. And in conscious of in view of the time, there's quite a detailed matter. Is that something we can leave for tomorrow?
It is something that we can leave for tomorrow. I mean, we can't do everything today.
But point of order, Mr. Inspector, the Council have raised it in their housing strategy paper. At the end of their document, they themselves actually talk about the allocation of Greenfield and Greenbelt sites. It's then been raised again by Mr. Hinton not less than 5 minutes ago as to why they haven't undertaken that review. That's the first time I've actually heard in open session that you haven't undertaken a review. In para 233, you say you will undertake a review, and I understood you had undertaken a review as part of the evidence process because sites being looked at were looked at as part of the sustainability strategy. My client's site was actually ticked as being suitable in both the sustainability strategy, the SHLA, and the March 2013 review of the previous evidence base. In all of those evidence-based documents, there's been a big tick against it. Now you've just announced to the world and their dog, you haven't undertaken a Greenbelt review. Which is it?
Can I, with respect, reserve that discussion for the appointed day for it, which is tomorrow morning? We're going to get there. We've got plenty of time. But what I do want to make sure is that, the burden of today's conversation, which is essentially housing numbers and the relationship between housing numbers and overarching strategy, is complex enough as a set of arguments and is something that, if additional work is required, that is programmed, and also that I have a clear understanding of the differences between you all that I can take away and consider. So, if we then look at the council's position, and there's another issue that caveats, in my mind, the position set out in this paper until we've fully had the discussions, and that is that where we take into account in your table 2 the additional sources of land supply that you've identified, what that doesn't take account of is the prospect that other sites slow down, other sites don't yield as much. So this is the obverse of the conservative figures argument. You've put an argument to me that your figures are inherently conservative and that I should therefore view them favourably, and we've explored the possible need for an additional source of evidence in relation to that submission. I'm now looking at it from the flip side and saying, well, what if we do find ourselves having had the detailed conversations that we'll have over the next few days with some individual sites that are currently assumed as delivering within 5 years that don't or partially deliver for some very good reason. Are there inherent vulnerabilities in the land supply scenarios in Table 2? On what account are you taking? Is your conservatism enough to absorb the fact that some things that are programmed to happen won't happen?
The original position of the 1st of April took account of risks identified at that time, and anything with what we consider to be an undue risk we didn't include in that position. So that was a conservative statement, if you like. We've taken the same approach to the position statement on the 1st of October. And in addition, because we know which sites we've been criticised about including, particularly from Gladman, we've taken out the sites that they're most critical of, and that is the alternative scenario in Table 2. The evidence from the other parties where it is critical of inclusion of sites is fairly site-specific. And I think Gladman are the party which identify sites by name and number. So that was an obvious scenario to run. And you will see from Table 2 that if they are taken out of the equation, there is still a 5-year supply. So we have tested that position by the scenarios based on the criticism that have been made by the other parties.
Okay, apologies, ladies and gentlemen. I was just adding to my note there so that I captured something that I think we're going to need to address in terms of some additional work that might be asked for. Now, I'm very conscious of the fact that normally in these discussions we hear from one side, council responds, the difference then becomes clear and apparent, and I just take the difference away and deliberate. But as I did indicate in my interjecting remarks halfway through the council's position, it's a little bit more complicated than that. So what I would like to do now is I'd like to give the council the opportunity, almost by way of re-examination, if you'll pardon the expression, to re-articulate to the extent that they feel it is necessary to do so their position as a consequence of the questions that have just been put. Then I want to come to this side of the room and deal with the issues that arise from the Toblerones, which I'm sure will then prompt a need for the Council to make some further and final responses before we come to the end of this session. So, Mr. Hinton, your opportunity to kind of draw together the threads, having just had that conversation with myself and responding to matters from across the table.
So I don't really feel I need to say much more. I think it's all in our written statements. Yep. I can trade verbal punches with people on the other side of the table, but frankly, it's not going to get us anywhere. It's all in the written statements. If there are any further matters that arise after the Toblerones have been dealt with, I'll come back. But I really think we've expressed our position, and it's for you to take it away and come to some conclusions.
Okay, fine. That's clear. That's simple. Okay, now, I think given the order of play that we've had before, if it's acceptable to you three folk, I'll run in the same order. That I'll go Gleeson, Gladman, Canwood. So, Mr. Pickup.
Just two short points on the basis of what we've heard. Can the Council, through you, sir, confirm that you do not have an up-to-date base at the 1st of October 2015 because the base does not include completions? That's the first point. The second point is that with the Eridge Road site, I don't know it, I have to confess that, but I understand from the discussions this morning it involves a fairly substantial high-rise building, and then therefore any completions and occupation can only come at the very end of that process once the building is completed in its entirety, and you still have not received any annual breakdown of the 130 units. It may well be that the 130 units, if they come right at the end of the 5-year period, because that's how long it takes to demolish what's existing and build what's proposed. And the final point I'd like to make, the relevance of the objectively assessed need. I'm sorry if I haven't made this clear, but the reason I'm referring to the objectively assessed need is because it can't be ignored. Even in this plan process, it can't be ignored. We know we're moving on to a new local plan whenever that arrives, and we haven't got a timescale for that. But it wouldn't be inappropriate for this allocations plan to identify more sites than are necessary to meet the requirement in the core strategy. The core strategy does not set a minimum, and it does not set a bar. So it's wholly appropriate for you to take account of the fact there is a substantial need that's not being met in the borough, and that this plan is still an opportunity to identify even reserve sites for the end of the plan period, should they be needed. And we can talk about the relevance of Greenbelt tomorrow, but that is the relevance of the objectively assessed need figure.
Thank you very much. And the Council can pick up when we return to them. So, Gladman.
Thank you, sir. Again, just a couple of brief points. The first one is, and it may be something that I've missed in the Council's submissions, and it is the issue about how we deal with the buffer and where we apply it and how we apply it. Now, obviously, you'll note that it's our position that it's applied to backlog and requirement. And as I understand it from reading the Council's tables, it's the other way around, but I don't know on what evidence they're basing that upon. I don't know whether that's something you wish to hear submissions from by the Council, or whether it's somewhere within the statements and I've just missed it. And if that is the case, I would be grateful if they could point me in that direction. The other point relates to what the Council said with respect to discounting sites out of their supply based on what was in our representations, and I accept that they have considered some of those and taken some of those out. One of the ones that doesn't seem to have altered, and I'm trying not to step into site-specific issues, but I'm struggling to not to do so, I'm afraid. So you perhaps give me some leeway in that regard. It's regarding the Knights Wood site, Knights Park site, and the number of units that's accounted for within there. Now, the council have told us that following the Hawkhurst decision, they've considered some of the issues which came out of that, and that's been reflected within their new housing land supply position, which is to be expected and to be commended. However, I'm not certain, and obviously we've also heard with regard to the Error Ridge Road site that they've had ongoing discussions with Dandara about the likely timescales behind that consent, and I would echo the points made by Gleeson's that is likely to come in a lump, and it's likely to come towards the end of the 5 years if it comes at all. It's our position that it won't, and that any slight delay will kick it into a next 5-year period. But in any event, they have had those discussions. Now, in the evidence submitted, I think it's by DHA Planning into the Hawkhurst appeal, there is obviously some correspondence there from the developers with regard to the Knights Park submission. Now, the view of the developer in that instance may well have changed now, I do not know, but the only evidence I have seen is what's in there, and they themselves, the developer themselves, cast light on the deliverability of that 550 units within the 5-year period. So I think it may well be worth, with your agreement, of course, that the council do a similar piece of work with regard to Knights Park that you've requested to Erridge Road and Paddock Wood. Oh, and sorry, just one brief final point. I think, I'm sure it wasn't the council's intention to paint it as such, but all the emission sites are not greenbelt sites. There are emission sites which are not within the greenbelt, just for clarity.
Okay, thank you very much. Canwood and Whitegates Farms.
Keep this brief, sir. Our evidence is that the council have fundamentally misinterpreted Core Policy 1, Core Policy 2 and 11 in terms of the priority, in terms of the sequential approach of sustainable housing site allocation. The council have failed to deliver housing over the last 10 years, over the last 6 years and over the last 5 years since the core strategy was adopted. Housing need in this borough has skyrocketed over the last 5 years, and I don't know whether that was because the housing evidence base was wrong, was fundamentally flawed back in 08 and 09. But how on earth housing numbers have skyrocketed from 300 to 640 odd in 5 years is quite beyond me. It's been my experience over the last 6 years, and I sat where Gleeson is sitting today. I sat here 6 years ago saying to almost the same characters on the other side of the table, you will be in a mess in 5 or 6 years' time, and here we are, in an awful, awful mess. And quite simply, I just think it's totally uncredible for a local planning authority to give evidence 21 days ago on the 10th of November which said X, and now they are saying Y. And we're not even sure what Y is, because Y has some form of discounting and it's conservative. We just want credible figures in credible locations. On my side, my clients have no issue with Persimmon and Ryden's land allocation per se. There is a need for far, far greater housing sites in this borough, but a better, more deliverable spread. The council, in my opinion, and in my experience from the outside looking in over the last 6 years, has lurched from everything going within the LBD on challenging sites to now almost everything outside on greenfield land for which we've had positive discussions but which there is no planning permission. And even if there was one, it takes years for a major strategic site to be delivered. Years. And it just seems to me, sir, we have a strategy of lurching. We go lurching from one extreme to the other. We need far, far more sites. You've got the evidence base, you've had the big ticks, you've had the iterative commentary from your technical teams and from your advisors that you've brought in. There's lots of sites in and contiguous with the LBD, which both the core strategy and your emerging evidence base say in black and white is appropriate. You've even got the exceptional circumstances laid down by the former strategic policy, which forms part and parcel of facilitating the regional hub status of Tunbridge Wells. It was deemed to be an exceptional circumstance. You've got all the reasoning behind it. You didn't need to be in this position. You've got a hell of a job on your hands, Mr. Inspector, and good luck to you. But quite frankly, sitting here, as desperately as I want you to find this plan sound, it's an awful job to do so, because you're being asked to take a major leap of faith on several issues. Thank you.
Thank you very much. Okay, I'll just briefly check. We do have the Civic Society, and just checking that CPRE are content at this juncture. Yes? Okay. Civic Society.
Thank you, sir. This is really going to be directed particularly at you, because I think you'll need to make a decision between these things. I wish to reiterate our concern, particularly having listened to this debate, the tension between getting the housing numbers and the danger that planning applications we've given through almost maybe on the nod, because the need to meet the housing numbers will deem to be much greater than the historical nature of the town, taking this heritage site. Will tourists still want to come to the town if they get what is currently proposed? And I listened to the council just recently with all the pre-applications, the meetings, that their conservation officer, I get a horrible feeling it's a done deal. And I would like you, sir, to really give good consideration to the other aspects, and so we don't just purely get driven by a need to get numbers on the door. Thank you.
Okay, right. So I'm going to come to the council, and then finally, by way of wrap-up, I'm going to spend a bit of time exploring a possible need for additional evidence on a number of aspects of the council's position. So, Mr. Hinton.
Thank you, sir. In no particular order. A point was made about providing further information about Knights Park, Union House and the Paddock Wood sites. Clearly, we can do that for you. In the case of the Gleeson point about the base figures, as we've already discussed this morning, and we haven't hidden the fact that the figures don't take account of completions, but we've explained what the implication of that is, and it's in favour of the objectors rather than the council. As far as the role of this examination is concerned, and to what extent the housing need figure of the objective assessed need coming from the SMAR is concerned, I think we would just have to agree to disagree with Gleeson. The legal cases are quite clear as to the scope of this examination, and it's not about taking account of levels of need that have been established since the core strategy was found sound. As far as the buffer position is concerned, I've seen the two references provided by Gleeson in their statement, although this morning they've mentioned that they could refer to others. Clearly, we weren't involved in those appeals, so I have no idea as to the context of the discussion of those points in front of those inspectors. I am concerned that the commentary in those documents tends to suggest that the buffer was being presented as some tool to be used to increase figures where there is a history of undelivery. when you look at para 47 of the MPPF, it's quite clear that the buffer isn't intended for that purpose. Clearly, under-delivery needs to be taken account of, but the MPPF is quite clear where it says whether it's a 5 or a 20% buffer, it's moving the figures from later in the period of the plan to that 5-year period. It's not multiplying the underlying need figures.
Okay. Now, just before I let you go and we then go on to looking at possible additional work related to evidence, I'm just referring back to the point that emerged from Gladman about the application of the buffer to backlog, because I may be missing a trick, but I don't think I heard a clear response to that particular element of the issue as they raised it there. And if it would help, I could return to them and just ask them to re-articulate that particular point, because it was made in the context of a number of points and quite a lot of other detail, and we may have just flown over it without fully understanding its import. Would that assist?
It may assist, sir, but I need to be clear whether or not it's been promoted as the purpose of the buffer is to move provision from the remaining of the period forward into the 5 years, whether that's their position, in which case I agree with it. However, if their position is that the buffer is used to multiply up the figure as some sort of penalty for previous undersupply, then I would disagree with that on the basis of para 47. And I'm not absolutely clear on the point that they're making.
Okay, well, before I go to Gleeson, then I'll fire my bolt so that Gleeson can address what I say as well in their response, so that we're all hopefully then singing on the same hymn sheet as a consequence. And that is, it was my understanding, Gladman, no, it was Gladman. Apologies, why am I saying this? Too many G's. Gladman. My understanding of what you were putting to me was essentially that any backlog in delivery needs to be taken into account and rolled into the aggregate housing number before the calculation and application of whatever the appropriate buffer margin is. Am I
correct?
Okay. Right.
I think, sir, the reason I've quoted the appeal decision I've quoted it is because, as I say, that there are numerous ones, various ones. But I think specifically the one at Tilehurst Lane, Binfield, Bracknell, I think the quote from the inspector in that particular report, to my mind, sums up the position the best. And I understand I think I understand what Mr. Hinton is saying. I disagree with him. And I think what we're talking about here is it's effectively the choice and competition to ensure that the delivery of that figure takes place, and that should be. We're not talking in the same sense with buffers that we always talk about. We're not talking about dragging in requirement from outside of the planned period or outside of whatever period it is we're considering. It's merely to ensure that number is met, and in order to do that, we would follow what the inspector sets out within that decision. And as I say, it's been set out at Warwick, it's been set out at Hereford, it's been set out at numerous other examination in publics as well, where we have had a very clear view from your colleagues, to the point that one of your colleagues actually told us we weren't discussing it and this is how it was done, which I found a very unusual position. I wouldn't expect you to do that, sir, but it has become something quite clear from our perspective on this side of the table through recent decisions.
Yes. I am very conscious that, the last thing I was going to do in this examination, for very good reason, was to attempt to place a "this is how it is done" type position before anybody involved here. We've got some difficult and complex issues with real implications for real people in the real world. But we do have to, sadly, hear the logic of the argument down to their roots. Otherwise, we're in danger of a very different scenario emerging, which is the plan being delayed because everybody believes I have somehow misdirected myself or have been unreasonable in the Wednesbury sense or whatever. So the reason for the somewhat mechanical and somewhat deliberative approach that I've been taking to this is to avoid giving anybody scope for running that sort of argument. Touch wood. Okay. But I now think I understand where your position came from, so I'll just return to Mr. Hinton and ask him for a response to that in the light of the conversation we've just had.
Thank you, sir. Without trying to complicate it even more, it may be that the council has misunderstood the point that was being made as well. So to try and cut through that, I can confirm that we don't take issue with the point that any deficit needs to be taken into account in terms of future supply. It can't be just forgotten about, which I think was the proposition that was being advanced in the appeal case that has been quoted. So we accept that you don't just forget about it. It needs to be factored into account. And I think that's the same point that Gladman is making in referring to those cases.
Okay. Which then leads me to a question, but I'm going to roll that into the homework, the discussion of, in inverted commas, homework items that I think arises from this. Now you'll have received a sense from my first round of questioning on the paper PS-37 that I do feel that in circumstances where you are asking me to pay substantial account and give significant weight to a rebasing of housing land supply figures that has happened quite rapidly and is somewhat different from the position that was originally articulated in evidence that was put in front of me not that long ago, that it is reasonable that I do some diligence about the foundation stone assumptions on which that relies. And the first of those foundation stones are, as we have already foreshadowed, understanding the drivers for the yield assumptions, annualised yield assumptions, for the Pettswood sites, PW3, Paddock Wood. What? I know why that arose. That's going back to deep history. That's the London Borough of Bromley. And in terms of annualised figures, it's a little bit more artificial in relation to RTW4 and Eridge Road, because fundamentally the proposition there is that you've got a big structure that needs to be demolished and then a flat development delivered that's likely to be delivered in one hit, probably fairly close to the end of the 5-year period. But nevertheless, I'd like to see the foundation stone for your proposition to me that that site is going to be delivered within the 5-year period. You've then asked, so that's kind of homework item number 1. You've then asked me to take comfort from the fact that your figures in underlying terms are conservative, which implies that you have evidence to hand that demonstrates that over a number of years your housing land supply assumptions have been overfulfilled. Now, if I'm going to put weight on that assertion, again, there needs to be an evidence base. Now, my feeling about what that consists of would be that you'd need to take at least a sample of sites over time and draw out what your initial yield assumption was for that site for AMR purposes, HLS calculation purposes, and then go back to say, and what eventuated, what was actually constructed, what's the percentage yield increase over what our original calculation was. And then draw that down to, a borough figure that then says, well, if on the basis of our analysis, we're performing positively in all of the sites we've reviewed, we believe it is reasonable to make an assumption that our HLS figures have been and are consistently conservative, and you can take confidence in them for those reasons. So that's the second item of homework that felt as though it was necessary. The third item, given the conversation that we have just had about backlog and buffer, I think we need, on no more than one side of A4 and in words of no more than 2 syllables, a clear explanation of how you have taken account of backlog for buffer purposes. So you're saying either you've fully taken backlog into account, and when you're looking at your updated 5-year housing supply scenarios at 1st of October 2015, in Table 2 of PS/37, where you set out your Liverpool 5%, Liverpool 20%, Sedgefield 5%, Sedgefield 20%, we just need to be absolutely, completely clear that your starting point was the meeting of backlog, then your forward delivery, and then the calculation in that sequence of the relevant buffer. Because if it's not, we're not on the same page, we're comparing apples with pears, and the figures become quite difficult to work with. Do those 3 items make sense? Okay, the next question then is, when by? And the third question is a procedural one, which is how to enable those people who've relevantly participated in this debate to put a final critique to me that I can then hear a response from you on that enables a hard line to be drawn under this discussion. And what I'm going to suggest is that is done in a written procedure. I really do not at this juncture see that there is an enormous amount to be gained by any further oral explanations. I think this is something where statements can be read, statements can be responded to, and then the Council can make a final summarising position statement available. I'm going to come to the Council last on that procedure point, but can I just go around the table? Procedural approach, broad response.
I completely agree. I don't see any reason why it couldn't be done in written writing. One query I would have is, would you be... well, I would be interested in seeing a similar piece of work for Knights Park as well as for Paddocks Wood and RTW4. Is that something you don't feel is necessary at the present time?
The reason why I didn't specifically ask for Knights Wood as well was because they haven't placed specific reliance on Knights Wood to get them to the position that they set out in PS 37. That was my starting point, but
right. You mean because it hasn't changed since the previous set? It
hasn't changed, and when we get down to the final, drivers of where things have changed, the push factors that push these factors over the line. I'm basically asking myself, what are those push factors? And I'm looking, at the bottom of page 3, and particularly the bullet points on the top of page 4, which tell us that they've factored in the Highgate Hill appeal result. That's a given. There are a given number of units. Then they've factored in RTW4, and they've allowed approximately 130. And they're adding 427 as a consequence of their consideration of early delivery on PW3. So that's why I felt that detailed evidence was needed on those sites, but maybe not on Knights Wood, because Knights Wood is not an instance of change and it's not being argued as the rationale for Council's conclusion that they were behind a line before and they're now in front of a line.
Understood. All I would say is that it is, from our submission, it is very important, and there was a significant piece of evidence as part of the Hawkhurst Hill appeal which challenged that assumption.
Okay. There is, though, the broader point, and the broader point is about the request that I've made for sample evidence that underpins the Council's consideration of their housing land supply figures as conservative. Now, Knights Wood does happen to be a fairly large site. It also happens to be a site under construction. There's a phase 1 consent, etc. So in other words, it's part of the evidence base, as I see it, that needs to be had regard to set out a stall in relation to the conservatism or otherwise of the HLS figures. So I'm not suggesting that they put detailed material to me in relation to answering the specific question arising from PS 37 about how they got across the line, because I genuinely don't think it's relevant. However, in relation to making the broader case for the conservatism of the figures, Knights Wood is one of the locations that does provide some data. So I guess I'd put it to the Council in these terms, that if they don't think Knights Wood is relevant to that second piece of analysis, it would be helpful if there was a brief explanation as to why. Because in principle it feels as though it is relevant to that second piece of analysis. Does that assist?
Yes, sir, I understand.
Okay. So, my feeling was that if that work's done, prepared by the Council, when can the Council realistically have that available? Because I'm very conscious that, the next few days are going to be busy. I'd rather have it realistic, considered, thought through, than have something that emerges.
Sir, I'd like to say it's going to be sooner, but given we've got to service the rest of the hearings.
Yes, exactly.
I would say it's, at the earliest, it would be the end of next week.
Okay. Essentially, I think that is a very realistic proposition. I would be very loath to seek to accelerate that delivery deadline. It's going to require thought. It's going to require resources, and my suspicion is that the thought and the resources are mainly sitting in this room. What I propose to do then is, if I take that away, but I indicate to you now, before we break for lunch, that what I anticipate doing is writing out, summarising that particular homework item, distinct from a to-do list that might arise from the detailed sites, because I really don't want to get the two mixed up. I'll aim to get that letter drafted over the next couple of days, and that what I would accept is that sort of timescale, so end of next week, then provide a fortnight bounce down, which essentially takes us to Christmas, that would enable other interested parties to respond to it, and then provide a date in early January for the Council to put a concluded position in the light of issues that might have been raised in writing. Does everybody feel that that enables us to get to the bottom of the evidence, to say nothing of anything else? Now, big caveats, big reservations about that also relate to the detailed discussions that we're going to have about deliverability on individual sites. And all I can say to you there is, rest assured, I will try and make the objects in space synchronise their orbits and, connect when I put my reasoning together. Okay. Gleeson.
Yes, in terms of your homework list, it's obviously, it's Gleeson's case that we're asking you to rely on the Housing Land Supply position as at the 1st of April, for the reasons we've discussed. I just wonder whether it would be helpful to you is if you saw amended versions of Appendix 1, Tables 1 and 3, that provided for the backlog plus 5% or 20% as an alternative, taking Gladman's point, just so we can agree the figures, even if there's a difference of opinion as to whether that's appropriate or not. And indeed, if it's the Council's position they wish to rely on the 1st of October, that there are similar tables, i.e. Sedgefield, plus 5%, plus 20%, attached to the backlog figure, so you know the difference between the parties. I'll just suggest that as it might be helpful, or it might not.
I'll hear from Mr. Hinton.
My immediate reaction is, with all due respect, I don't think it will be helpful, because our case, as I've presented this morning, is that things have moved on. And if we go back to the 1st of April, it's an added complication. So I think it's complicated enough. So I think we need to base any submissions on what we believe is the current position.
Can I maybe resolve this in the interests of being efficient and in the interests of not asking people to do massive amounts of additional work unless it is really necessary? One of the things that I've got to do is to go away and mull over everything that's been put to me in writing, which I've obviously done in preparation for this hearing, but also the balance of the oral arguments that until now I haven't had in my head. And it, as I've indicated to you before, if significant issues emerge in my thinking, it's clearly incumbent on me not just to sit until the end of the report writing period and then put out a report of a kind of bombshell nature. Clearly, it will be incumbent on me to then write back to the parties if, in late December or early January, having sat with it on my desk for a week or so and read it again and reasoned it again, I'm feeling that, I need to move in a particular direction. I can then articulate the questions I need to articulate and commission the extra work, and if necessary, open a hearing to enable that to be examined. But I would really prefer to deal with it that way than to give the council a homework list longer than arms and then end up with a situation where some of that work inevitably might be unnecessary. So we content to leave the list as it is. In which case, ladies and gentlemen, long and complex though the arguments have been, I do think we've probably reached as close as we're going to get to a concluded position, certainly a position that enables me to do the deliberation I've got to make. So I'm proposing that we close this session now and then move after the break into the new world where we're looking at individual sites. It only remains for me, therefore, to thank everybody who's come to this table and grappled with the complexities of the evidence around housing land supply, and put significant issues, powerful arguments to me on all sides that I then need to go away and deliberate on with very great care. Thank you very much, ladies and gentlemen, for all of your contributions. We will resume at 2:00.